Hi everyone, this is Mike Davis from Venable. Thank you for joining us today for our presentation on federal and state funding in the wake of a disaster, what you and your organization need to know. I want to spend a moment introducing the speakers. So first we're going to have Marion McFadden, who's going to be speaking on federal issues and also on some state issues. Marion is the Vice President of Public Policy at Enterprise Community Partners. She served as Deputy Assistant Secretary for Grant Programs at the United States Department of Housing and Urban Development, also known as HUD. And she oversaw affordable housing and community development programs, including the Community Development Block Grant Program, as well as others, and CDBG disaster recovery funds, including in the wake of the National Disaster Resilience Competition grants. Unfortunately, our speaker, Terrence Brody from Ankura Consulting, is not going to be able to join us today because he's in Puerto Rico and doesn't have the capability to call in. So Marion will be pinch hitting for Terrence in that regard. And then we have two speakers from Venable, two of my colleagues. Diz Locaria is a member of Venable's Government Contracts Group and specializes in working on federal grants. And our colleague Melanie Topman, who serves in the same capacity and specializes in grants. And then this is Mike Davis from Venable. I'm in the insurance group, and we'll be speaking today at the end about insurance issues. And Diz, Melanie, and I have worked on several disaster response projects, including in New York as the result of Superstorm Sandy, and also in New Orleans as a result of hurricanes there as well. So the first topic today that we're going to be covering is the federal perspective on grants, and then we'll be turning to the state perspective and the municipal perspective. Then we'll be talking about the early legal issues that your organization should be concerned with, and then we'll finish up with insurance recovery. And at any time, if you have questions, there should be a link on the program, and if you email those in, we'll try to answer them as we go, so don't feel the need to save them till the end. So with that, Marion, I'll turn it over to you for some observations on the federal perspective, and then in your, with your Terry hat on, the state and municipal perspective.
Thanks for the intro, Mike, and to you and Diz and the rest of the Venable team for the opportunity to do this today. Over the past few weeks, I've been so glad to see so much interest in understanding how federal recovery grants work and what we can all do to improve their administration. Because if there's one thing we all know from watching past disasters is that we need to get better each time and shorten the time it takes to get people back in their homes and get communities fully functioning again. I'm going to talk about the funding that's already available for the recovery from the 2017 disasters and offer a few observations from my experience in the federal government. In my current role, I run the policy team at Enterprise Community Partners. Enterprise is a large national nonprofit organization dedicating to making well-designed homes affordable for people of modest means, including after natural disasters. We also do community development work, bringing capital investments to community facilities and businesses. After Hurricane Katrina, we developed affordable housing in the Gulf Coast using low-income housing tax credits and HUD Community Development Block Grants, or CDBG. And the experience that we gained there informed Enterprise's work in New York and in New Jersey after Hurricane Sandy. In New York, we established a mobile unit of pro bono architects, engineers, and designers to go on site and assist property owners with the rebuilding process, particularly so that they could keep the future in mind and ensure more resilient rebuilding. We also work closely with public housing authorities in New York, assisting them in making their properties safer and more flood resistant. Our public sector consulting group, Enterprise Advisors, is tasked by HUD or hired directly by jurisdictions to do strategic design of programs and compliance work. And so after Hurricane Sandy, we helped New Jersey set up its HUD-funded housing recovery programs. I'm so sorry that Terry can't join us today, but I did get to work closely with him when he was doing that work setting up New Jersey's program. So I hope my Terry hat fits well enough for the webinar today. We also at Enterprise do resilience initiatives, including toolkits for building owners to prepare for and recover from disasters, everything from tracking tenants to mold remediation. So we get pretty technical. And then on the policy side, my team and I have been spending a lot of time on the Hill, advocating for additional resources for recovery from the latest disasters and making recommendations to Congress and the agencies to try and ensure that the recovery from Hurricanes Harvey and Irma and Maria will incorporate those lessons learned from the past disasters and set the stage for a quicker and more equitable recovery. I've been heartened to see several hundred national and local organizations coalescing around central themes for improving how the federal government shapes recovery work, including the need to ensure an equitable recovery that reaches the people most in need. My old boss at HUD, Sean Donovan, used to say there's never a time when people need the federal government more than after a catastrophic disaster. And I think about that all the time, that people who never thought they were going to need the government will need help, but also folks who were struggling before the disaster are really going to need it the most. So I have been with Enterprise for just over a year, and before coming to Enterprise, I spent 15 years at HUD working on every HUD-funded disaster from 9/11 to Hurricane Sandy and beyond, as Mike said. I think most people are unaware of the enormous role that HUD plays in long-term disaster recovery, but in fact, HUD received the single largest grant from Congress after Hurricane Sandy, more than $15 billion. Most of the time that I was there was spent in the Office of General Counsel, where I helped create and administer grant funds. In late 2012, I had the opportunity to set up and run the Hurricane Sandy Rebuilding Task Force, which was set up to coordinate the 24 agencies and offices of the federal government to work closely with the affected state, local, and tribal governments. And after that, I moved to HUD's Office of Community Planning and Development, or CPD, where I ran programs directly, including the National Disaster Resilience Competition, which was a first-of-its-kind effort to spur grantee innovation in disaster recovery. So I'm going to talk mostly about HUD's grant funding because I know it best, and also because it's large and flexible, and I think will be the real difference maker for tens of thousands of people affected by the recent disasters. As the terrible news of the grim realities of impacts from Hurricane Maria start to filter in, I think we're all feeling a bit overwhelmed by the pictures and stories of the suffering of fellow Americans in Puerto Rico and the U.S. Virgin Islands. Recovery from Hurricanes Harvey and Irma has begun in Texas, Louisiana, and Florida, but still far too many people there are displaced and struggling to find a path to stability. Based on the scale of damage, I'd say it's clear that recovery will be measured in years, not weeks or months. So on September 8th, which was after the terrible aftermath of just Hurricane Harvey, I believe, Congress passed a bill for hurricane recovery that included $7.4 billion for FEMA, Federal Emergency Management Association, for their disaster relief fund to keep their day-to-day operations going. It gave $450 million to the Small Business Administration, or SBA, for disaster funds for loans to businesses, but also to homeowners. People tend not to know, but SBA does assist homeowners after disasters. And then unexpectedly, that initial package already also gave an additional $7.4 billion for long-term recovery to HUD. I say unexpectedly because the administration didn't actually ask for it. Usually after disaster, the administration has the first volley and says, here's what we need, and then the Hill responds. But the Senate got ahead of the White House and went ahead and gave them the same amount they were giving to FEMA. So that package also included an extension of authority for FEMA to operate the National Flood Insurance Program through December 9th. And the bill was great for preventing FEMA from running out of money for emergency assistance. It lets the SBA keep making their loans and allows HUD to roll out new grants. And the law actually didn't limit the recovery to any specific storm. So even though it was just after Harvey, the funds are available for the 3 worst hurricanes in recent history, as well as previous events and even for any major disasters that occur between now and the end of the year. But, you know, this $15 billion that's available now is really, truly just seen as a down payment on what's needed. And we're expecting Congress to act at least once more this fall with additional funding. And we could see even additional packages beyond that with both appropriations and tax relief. Closest thing we can look at would be Hurricane Sandy, which struck the East Coast in 2012 and damaged or destroyed 650,000 homes caused billions or tens of billions of dollars in infrastructure, and there Congress passed a more than $50 billion recovery package that included grants for FEMA and HUD, but also DOT, Army Corps of Engineers, Small Business Administration, and other agencies. So I would not be surprised if we were to see a much bigger package coming down the pike. In the meantime, FEMA is going to use its existing authorities to make grants to individuals for their emergency expenses, and will provide enough funding for homeowners to do minor repair work, but not large-scale rebuilding. Those grants from FEMA cap out at about $33,000. So when you take into consideration how many costs people are trying to pay once displaced from their homes, including temporary lodging, it just doesn't go as far as it should for many people. FEMA is also going to provide grants for community-scale rebuilding through the Public Assistance Program, and all those funds will be administered consistent with existing regulations. Same thing with the SBA. They will make loans according to their usual processes. The interesting part of the CDBG-DR program at HUD is that unlike annual grants made under the CDBG program, the disaster recovery part doesn't exist until Congress passes a special appropriation of CDBG-DR dollars, because a disaster or a series of disasters has been so financially overwhelming that these permanent disaster recovery programs, like the FEMA individual and public assistance grants, the SBA loans, the Army Corps of Engineer, infrastructure authorities, are not going to be sufficient to enable the affected communities to recover. So CDBG-DR only comes on the scene when the disasters are really bad and the existing programs are overwhelmed. But these special appropriations have actually become pretty routine. In the 16 years since 9/11, Congress has actually passed 15 rounds of CDBG-DR. So the CDBG-DR laws, including the one just passed, actually give the HUD Secretary the discretion to waive both statutes and regulations and issue alternative requirements to tailor that annual CDBG program to the disaster recovery context. The broad waiver authority that's provided under the law to the HUD Secretary actually holds back any new authority to waive civil rights, non-discrimination, labor standards, or environmental review requirements, which are important public policy points, but at least in terms of labor standards and environmental review, would probably be the first things that jurisdictions administering programs would want to waive, because they add a lot of time to the process of recovery. So these HUD funds can be used for almost anything in a community. So they can be used for repair and rebuilding of rental and homeowner housing, the buying of properties to move people out of harm's way, economic development, such as grants to small businesses, and infrastructure work. CDBG-DR is often used to fill the gaps in larger infrastructure projects that are partially funded by FEMA, DOT, and other federal agencies. And layering different federal funding sources together requires recipients to be strategic about choosing which sources to use to get projects done. It's a very complicated process. I'm sorry that Terry's not able to tell us some of the war stories that they went through in trying to make these choices. I would note they're also subject to a lot of political pressure. So once the jurisdiction's making these decisions, who they're hearing from, because no matter how much money is provided by Congress, it's never going to be enough to make everyone whole again. And so tough choices have to be made. So once HUD gets the money from Congress, and now that they're looking at the $7.4 billion, they set requirements for those funds by issuing a Federal Register notice that lays out the rules. So unlike the permanently authorized programs, HUD issues the rules for CDBG-DR without going through the regular process of proposed rulemaking. So the public has never really had an opportunity to offer comments on them. But on the plus side, each new appropriation offers an opportunity to change the rules from before to incorporate those lessons learned from the past recovery efforts. The HUD funds require a key set of decisions to be made by HUD and then by direct governmental recipients of the dollars after consultation with affected citizens, and ultimately by property owners seeking to use the funds. The first decision that HUD has to make now is how to allocate the funds, including not just dollar amounts, but also which affected units of government will receive grants directly from HUD. To support this decision, HUD looks at other agencies' damage estimates to inform their allocations. Traditionally, HUD has based formula runs on uniformly available federal damage data, reflecting uninsured losses to housing, businesses, and infrastructure, comparing apples to apples to ensure that different disasters are treated the same as much as possible. So those commonly used data sources include FEMA assessments made under the Individual Assistance Program, and then HUD calculates rental housing damage estimates. Since FEMA doesn't do those, it uses property damage assessments as a proxy. They also look at SBA disaster program damage assessments and loan amounts, and then for infrastructure, FEMA Public Assistance Program data. The formula process at HUD is data-driven. Yes.
Sorry to interrupt. We had a question that I thought might be relevant. Do you have an idea as to what the timing would be for when the allocations to the impacted communities are likely to be made?
So the word from HUD is that before making the allocations, they want to truly be able to assess the damage. And they started with one disaster, and now they're on 3 major disasters from 2017. So my best guess, based on conversations with HUD, would be it won't be less than a month. It won't be any less than a month from now. It could be as much as 6 weeks or 2 months from now.
Got it. Thank you. And for people listening to the, I'm sorry.
Great. I would just add, from spending a lot of time on the Hill, they're getting a lot of pressure from the delegation to get at least an initial allocation out the door. So if HUD were to only take $1 billion of the 7.4 and allocate it among jurisdictions, it would allow folks to start setting up their programs and doing the back of the house work to spread the money. But HUD wants to be sure. It's also the first time that the Trump administration and Secretary Carson have been called upon to make a formula, to create a formula. So they have to make some tough decisions there. And so while this formula process is actually data-driven, there is some opportunity for leadership to put their thumb on the scale in favor of a certain industry or a certain jurisdiction by choosing one variable for calculating loss over another. But as long as the uniform data are used, the results are going to be transparent. And once the final decisions are made, HUD publishes the formula in the Federal Register for everyone to see. So if anyone's really interested in the formula, on HUD's website, they publish all the Federal Register notices they've done dating back to 9/11 and possibly before. And in those allocation notices, there's an appendix which talks about all the variables used in making those decisions. The other big choice for HUD at the Secretary's discretion is the selection of grantees. So which jurisdictions are going to be chosen to receive the funds directly from HUD. Congress gave the Secretary broad discretion to choose from the affected recipients of annual CDBG grants. So just to give you a sense of context there are 1,200 units of general local government, so cities and counties and territories, that receive annual CDBG funds plus all the states. So for example, after considering the damage in Houston, the Secretary could choose to give funds directly to the city or to the county or to the state. And it's possible that Secretary Carson would choose to make awards only to the highest unit of government, handing the funds over to the governor rather than reaching down to the units of general local government, like the counties and cities. In Puerto Rico alone, there are more than 25 municipalities receiving annual CDBG funds. So in making the decision, HUD has to, under the law, has to assess potential grantees' financial controls and their procurement processes and their procedures to prevent windfalls that could potentially be created for awarding grants for costs that have already been covered by insurance or another agency's assistance. HUD is likely to balance factors such as how the jurisdiction performs in managing annual CDBG and other HUD funds, including CDBG-DR funds, as well as HUD's own capacity to manage multiple grants over the years to come. I think it's worth mentioning that HUD's Disaster Recovery Program Office has fewer than 20 people in it. So I think it's, they have an open portfolio of about $20 billion and 20 people. So I think it's unlikely that we'll see dozens of grants resulting from the 7.4 appropriated this year. and the additional money coming down the pike. So the recent hurricanes have presented exponential challenges in recovery and rebuilding, and it's going to be a long-term effort of magnitude far surpassing the current capacity of states, counties, or cities that are going to receive the funding. No unit of government ever has the existing capacity to administer a recovery program at the scale required after a catastrophic disaster like Harvey or Irma or Maria. And whoever is chosen is going to need to scale up exponentially to receive hundreds of millions or billions in recovery grant funds. Even New York City, HUD's largest local government to receive annual CDBG awards, faced tremendous growth pains trying to scale up its program to accommodate the influx of more than $4 billion after Hurricane Sandy. So it's clear that any level of government receiving funds is going to need the support of HUD and the existing stable of technical assistance providers, which may include enterprise. And they're going to need to work closely with other units of government, community organizations, universities, and the private sector. I think we're going to need, as they say, all hands on deck for the recovery effort. I really appreciate the opportunity to be here and look forward to hearing questions from the other panelists. And I'll turn it back to you. Thanks.
Okay, great. Diz and Melanie are going to talk about the legal issues with a focus on the most important legal issues in the early days after a disaster strikes and funds are available.
Absolutely. Thank you, Mike, and thank you everyone for joining today to hear us kind of talk some of these unfortunate issues. So what we wanted to do is talk about what we call early legal issues. And the reason we categorize it as early legal issues is that we could spend an hour and a half webinar probably talking about any one of these, or even a day-long webinar talking about any one of these issues and really digging into all the requirements, because there are many. But we wanted to at least identify some of the top-level things that folks need to be thinking about as you know, funds start to roll into their various locales, as Marion explained. And Marion went through some of this, but I want to dive into it with a little bit more detail here, you know, because the first thing, you know, when you are a grantee, and as Marion explained, you know, it could be at the state level, it could be at the local level, but the grantees are going to be those local government units. They're going to be the ones that receive the significant amount of, whether it's CDBG funds from HUD or FEMA funds, and then they're going to dole those funds out to the beneficiaries beneath them, and those beneficiaries are then, you know, going to use it to recover and rebuild. And so it's important wherever you sit in this spectrum to understand what actually applies to you from a legal perspective. And so, as Marion mentioned, there's already been some appropriation. We do largely expect there to be additional appropriations for recovery and rebuilding, but there is some initial appropriations out there in the wake of Harvey and Irma. And so that appropriations law has with it, you know, certain requirements embedded in there, how that money is to be spent. And so the agencies are going to be limited in spending the money in a certain way. They're also limited by the program itself. So for FEMA, it's under what's called the Stafford Act, and for HUD, it's under the Housing and Community Development Act of 1974. So those statutory programs have limitations as well, and it's important that folks are aware of that, so they can accommodate their program, whether you're a grantee or a beneficiary or sub-grantee under these organizations. But it doesn't stop there, because that is kind of a high-level framework for how this money gets rolled out. There are a number of other regulations and things that are going to be impacting these dollars. And one of the most important ones is what's called the Uniform Guidance. So the Office of Management and Budget in years past had a number of what they called OMB circulars that applied to grant funds. And it talked about all kinds of different ways on how you specifically deal with grant funds. Well, a few years ago, OMB decided, under a lot of encouragement, to consolidate that guidance. And so they created a super guidance, or a uniform guidance. They issued that in 2013. It became effective in 2014, although I'll note that the procurement portion of it is technically not in effect yet. it actually was given, there's a number of extensions on the application and implementation of the procurement requirements until December 25th or 26th of this year. That will go into play. But there are still procurement requirements under the older circulars that you must abide by. So for sake of simplicity, we're going to talk about some of those today, but we're going to talk about them under the new requirements, which are, there's a couple differences that we can highlight today. So you're going to have this overarching uniform guidance regulation. But then as Marion mentioned, there's also going to be some specific regulations regarding these particular funds. So they're going to be subject to the statutory, the appropriations law, the uniform guidance, and then these specific regulations that either FEMA or HUD or the Small Business Administration, whoever is doling out those particular funds, are going to be attaching to it. So it's always going to be important to identify where each dollar is coming from. Is this dollar coming from FEMA, in which case you're under the Stafford Act, you're under the uniform guidance, and then you'll be under FEMA under Title 44, which are the FEMA regulations. Or is this money coming from HUD? So you'll be under the Housing Community Development Act, you're going to be under the uniform guidance, but then you'll be under Title 24 of the CFR. And so it's important to know where these funds are coming from so you can set up your program correctly, or if you're a recipient of these funds, how to deal with these funds and make sure that you're using them correctly. Now, one thing also...
This is Melanie.
Yeah,
hey,
absolutely.
This is Melanie. Real quick, let me just... So this sounds great, right? Totally helpful and incredibly overwhelming at the same time. What are some of the things we can do to sort of break it down? Let me sort of ask the question to you, but then also provide a little bit of an answer in some of our past representations of what we've done. Somebody in your organization, if you are at the state, if you are, at a local government, if you're at a university, wherever you may be, somebody needs to sit down and very specifically review the requirements on each lane of your requirements. So you have like environmental requirements, you have procurement requirements, you have, Michael talked about sort of how the insurance piece plays in. Somebody needs to sort of sit down and take the time and sort of print off the statute, print off the regulations, go through and think, especially if you're at the state level, there may be opportunities to adopt, just adopt the federal approach, or to say, no, we want to provide state procurement law in the event that, unless, they're conflicting, think through how the administration of each of these requirements is going to work, and almost make a sort of compliance matrix chart for yourself. Because if you do not do this, you're going to be sort of going down a path that you may have to change, a year down the road, and then it's not helpful to anyone. So I would say one is, it sounds so basic, but it's like you'd be surprised how many people don't read the statute. They don't know what's in, what they're statutorily required to do. And then two, if there is a question, if there's something where you're thinking, this would be very difficult for me to comply with, or the state, the city, the university to comply with, can we use this other method, or can we, do we actually have to comply with this? Is this really, relevant to the funding? Have that conversation now, because again, what we've seen in the past is you sort of, there's an urgency to get the money out the door, and we get it, and absolutely there is quite literally an urgency to get the money out the door, but we have to do it with a way that is diligent and consistent with the law. And if you have conversations now, if you sort of identify the areas where you have risk of noncompliance, and have conversations with the United States government now, it has been our experience that tends to lead to a more favorable resolution, 2, 5, could literally be 10 years down the road when all of this comes up for audit. So that's, this is grant law, unlike government contracts law, it's layered in its legal requirements. Just map through the legal requirements, get someone to help you do that, or do it yourself, and make sure you know exactly what you are required to do. Sorry, Diz, didn't want to take over your time.
No, that's perfect. Actually, the next slide talks exactly about that, which is, make sure that your team has the staff, appropriate staff, for looking at these requirements. And like Melanie said, printing these out and actually going through them. And we do get it that get this money out at all costs. However, what we've seen, in our representation of our various clients, is that many years after the fact, an OIG auditor may come in from one of these agencies and ultimately disallow some of these funds. And we're not talking about nickels and dimes here. We're talking about millions of dollars. And so the agency, whether it's a local entity, a state and local government, or a university, or a hospital, or whoever you might be, the last thing you need is 5 years after the fact to be questioned on how you used the money and then have a big portion of it disallowed. So it is absolutely imperative to making sure that you have someone in your team who's responsible for understanding these requirements and these overlaying requirements, and making sure that you have a way to address these requirements. And that might be developing a compliance matrix, and then documenting your rationale as to how you believe you're complying with these requirements. If it's questionable, work with the agency and try to get their buy-in. If you can get the agency's buy-in on something, you're going to have a much easier job of selling that down the road, that this is what we came to under exigent circumstances, and we believe that this comports with the requirements. And then also keeping an eye on what the agency's activities are, because sometimes what we saw in New York was HUD issued a regulation in December of 2013, for a big chunk of the money. That was shortly after Superstorm Sandy. But there were several other regulations issued over the subsequent 6 months and a year that gave additional guidance and additional standards. And so, even though you might do this at the outset, you got to remain vigilant and stay on top of it the whole time. So identifying and creating a system to ensure that kind of legal compliance is absolutely critical at the outset. So you're setting up your program in a way that comports with these requirements. Okay, so then, what else? What other big topics do we need to look at in terms of, when you start getting these federal funds? Well, we've kind of identified 4, and if time permits, we'll talk about a couple additional things. But, we're going to talk a little bit about subrecipients versus contractors. What's the difference between these two? We'll talk about procurement practices, as well as subrecipient monitoring once we identify what the difference is between these. And we're going to talk a little bit about some cost principles. So with that, I'll turn it over to Melanie to talk a little bit about the difference between subrecipients and contractors.
Okay. Again, thank you, Diz, and thank you, everybody, for listening to us. I'm sure you have other things to do on a beautiful Thursday afternoon, but we're delighted to have you. One of the things that we have seen sort of be most troubling for state and local governments to figure out throughout the course of funding. I mean, this sort of happens, there's a sort of move to get funding out the door initially, often in existing contract vehicles. And then as the sort of recovery effort unfolds, obviously there's a number of contractual vehicles that come into play. And one of the things that is just always an issue, and I think it's because it's just not very clear, is what is the difference between a subrecipient and a contractor? And the difference really we'll sort of go through, it sometimes can be in the eye of the beholder, and I know that's completely unhelpful, but we'll go through the law. But it's so important for your organization to give thought to this question of how to give the money out, how to sort of move the money. Are you going to use a subrecipient? Are you going to use a contractor? And the reason is because there's an entirely different regulatory paradigm that applies to a subrecipient versus a contractor. And there's an entirely different way of procuring the goods. Obviously, procurement, applies to contractor versus a subrecipient. So it's so important to kind of understand when you use a subrecipient, when you use a contractor, what sort of things you have to do leading up to issuing a subrecipient, what you have to do leading up to issuing a contractor, and what are sort of the benefits of using one versus the other. So let's dive in more substantively. Oh, let's see. Okay, so a subrecipient is basically, it's like taking all of the regulations and moving just a tier down. You are making a sub-award. You're saying, okay, if the purpose, we're getting a grant from the United States government to effectuate a purpose, to help aid in the relief and recovery effort, and there's probably more specifics that will go with that. If we are moving that thing of value, that money down a level to a city or to another state entity, often it is most appropriate to use a subrecipient agreement. Grantees are required to follow all of the sort of uniform guidance requirements that DIS just articulated, all the statutory requirements that DIS just articulated, and so are sub-grantees, these subrecipients. So subrecipients they have to comply with everything that you would have to comply with. Contractors, on the other hand, are just that. They're they are the entities that you go out when you want to buy goods or services. If you want to, as a state, purchase any service for picking up trash, if you want to purchase any service for helping you on IT, if you want to buy bottles of water, you are entering into a contract to do that, a procurement contract. And with that comes all of the procurement requirements that you would normally see. Okay, so what happens with subrecipients? First, you've got subrecipient monitoring. So a subrecipient, again, a non-federal entity that receives a subaward from a pass-through entity to carry out part of the federal program. So again, just like we said, you're taking all of the sort of mandates from the federal government to say, please do this thing that we would like for you to do, and we're going to carry out this program. It doesn't include, for example, a beneficiary. So when you give money to an individual, that's not a subrecipient agreement. This is more of, sort of moving money from entity to entity. Unless provided otherwise, like we said, the terms and the conditions of the federal award flow down to the subrecipients. So grantees, but when you do that, you have to enter what's called subrecipient monitoring. So what do you have to do? Grantees must, one, review financial and programmatic reports. So if you are looking to make a subrecipient, enter into a subrecipient agreement, you're a state or a city, and you think, okay, I've got this other entity, maybe a university or somebody else I want to enter into a subrecipient agreement with, you have to kind of do a little bit of homework before you enter into that agreement, and that is by law. You have to review their financial and programmatic reports. You have to recommend any corrective action for deficiencies, so say they don't comply with the regulations that they say they're going to comply with. You have to actually you don't just sort of get to pass the money off. You have to actually take the time to put together audits, corrective action reports, on-site reviews. You've got to follow up and ensure that subrecipients take timely and appropriate action on all deficiencies. So, if a subrecipient doesn't do what they say they're going to do under the regulations, you've got to actually go out there and say, hey, you told us you were going to do this. Why haven't you done it? If you don't continue to do it, we're going to take corrective action against you. And let me point out, and this is a little bit sensitive, but often what we see is when you give money, if you're a state entity and you give money to another state entity, it can at times be difficult to call your other state entity out. There might be a lot of political nuances in that. But that is what the federal law requires of you. I mean, you are required to sort of pass through all of these regulations, all of these requirements, and then you're required to really truly monitor your subrecipients. You've got to issue management decisions on audit findings. So, everyone has to comply with this A133 audit. If you have audit findings that come back, you've got to actually make decisions about it. You've got to verify audit compliance, and when necessary, you have to consider taking enforcement action. So those are, sort of the things that you broadly need to do when we say subrecipient monitoring. They're easier to issue at the outset. You don't have to go through what we're going to just talk about with procurement, but they are harder on the back end in the sense that you have to actually take the time to go through and make sure that your subrecipients are doing what they're telling you they're doing in some sort of meaningful way. Okay, subrecipient monitoring continued. What are ideas for monitoring, what you may do? This is not what you have to do, but these are things that people find particularly helpful. You can provide training and technical assistance. So again, say you're a large state government, you've got different state entities that you're going to be funneling some of the money through. It may be advisable to you to send some people out there to train your other state government entities or your universities, whomever you're sending the money through, on the requirements. That compliance matrix we just talked about, you might want to take them that compliance matrix and say, look, here are the things that you are signing up for. Here are the things you're required to do if you take this money. You may decide to perform on-site reviews of program operations. So, and this is sort of true of all ethics and compliance programs, you want to kind of get your face out there. You don't want to just rely on paper. It's just never advisable to do that. You want to do on-site visits. You want to say, hey, show me your process in action. Walk me through what you're doing. Show me the financial documents. Show me your timekeeping reports. Give me some idea of what you're doing. This is what the federal government, by the way, is going to probably do with you. So you just want to know ahead of time, is there some sort of deficiency from our subrecipients that we need to address now? And our experience has always been, when you go in person, you really actually have an understanding of what's going on. And then you may provide agreed upon audit procedures and requirements. So what you might do ahead of time, which I think is a good idea, is when you give this money to your subrecipients, you say, look, here is how we're going to audit you. We're going to audit you on this schedule. This is the type of things we're going to require of you. This is the mechanism for you to respond to us. And here's how we're going to work through a dispute. So that everybody kind of knows what the expectations are up front, and they have an idea of how to interact with you through the course of an audit. Diz, do you have anything to add to that slide?
No, I think you've covered it well.
Okay. Can I turn it back over to you for procurement?
Absolutely. Thank you. So, as Melanie mentioned, there's this important distinction between subrecipients and contractors. As she mentioned, you don't have that competition requirement when you award a sub-grant to a subrecipient, meaning you do have a competition requirement, generally speaking, when you award contracts with these federal funds. And so competition is generally required. There are different levels required depending on the size of the contract, but keep in mind these levels are relatively low. For instance, a contract less than $3,500, it doesn't really require competition. You just need to make sure the pricing is reasonable. Contracts between $3,500 and $150,000, you need to have some price quotes. Typically, 3 will satisfy, and then again showing that the price, the offeror that you selected, it's reasonable. But you need to have a qualified number of sources. it's contracts over 150,000 where full and open competition is generally required. And the full and open competition is one of the major distinctions between the old regulations and the new regulations. Because the old regulations, there was some wiggle room there. The new regulations have no wiggle room. For all contracts 150,000 or over, you must have full and open competition, with one exception, which is that sole source contracts are permissible under limited circumstances. And so, obviously, number two here, public exigency or emergency is probably the most important one for us to recognize today, given the situation. There is no question that a declared disaster is a public exigency and emergency. However, again, we're trying to look at the long game here. At some point, the exigency will subside, and there will be a point where, okay, now we're on rebuilding mode, and the exigency is simply not the same. And what's going to happen is an auditor is going to come in many years after the fact and make a subjective determination that exigency was over. Now, you're not going to know that on the ground. So there needs to be some reasonableness, and what we would advise is a memorialized rationale for when the exigency has subsided and it makes sense to start procuring in the normal manner, i.e. issuing an RFP, putting it out there for the world to respond, selecting an offer on a most advantageous basis, and including all the requirements of a federal contract, which are all articulated in the uniform guidance. So you can award on exigency, but we've seen time and time again that you can't simply rely on that for a 5-year recovery. At some point, someone's going to say, whoa, this needs to be competed. This contract, for response and initial recovery, absolutely, but rebuilding probably should have competed that. And so it's sometimes challenging, but organizations need to think through, okay, at this point we're ready while these people are doing kind of the recovery and the initial assessments or whatever it's going to take to get to rebuilding, we should start preparing contract RFPs for the rebuilding portion. And so it's important to keep that in mind because you got to kind of think things through, because what's not an exigency is the failure to act. So because you didn't plan accordingly, you can't create an emergency. The OIGs aren't going to agree with that. So you got to plan accordingly and think about the future so you can get the correct contract in place. Now, an important factor, competition is great, and it does alleviate some of the burden when you're letting that contract. You only have to do what's called a price analysis, which means you can compare offerors, and then your standard is not lowest price, technically acceptable, but rather most advantageous. So you can factor in things like, your confidence in their ability to perform, their past performance record. You can factor all those things in and award to a more expensive offeror because they're more advantageous. But you're also able to compare and make sure that there's price reasonableness. When you're in a situation where you're sole sourcing, you have no one to compare to. So you have to take an extra step called a cost analysis. And a cost analysis requires you to analyze the prices proposed by the offeror, but to dig into those and ask them specifically what their profit margins are. And if they're unwilling to give that to you, you have a real you're in kind of a rock and a hard place, because the regulations specifically provide that you've got to do a cost analysis and analyze profit separately. So if these guys want the contract, then they're going to have to cough up some profit information for you to analyze that and determine whether that is in fact fair and reasonable. So how do you determine whether a profit's fair and reasonable? Well, you can look at the industry, and hopefully one of the things that folks can sometimes do is work with HUD or work with FEMA to find out what reasonable industry standards are. You can factor in things like they're going to go without payment for many, many months until we get the money from HUD or FEMA. So, we've had clients that have relied upon contractors for more than a year to provide the financing of the project because they knew the insurance funds and the FEMA funds were not going to be flowing in right away. And so contractors took it on themselves to have this long payment window. And that you can factor all that in to what's a reasonable profit margin. But it's an extra step doing this cost analysis. Next slide. So it's critical, again, similar to what we talked about before, it's critical that you establish what we're calling here a workable procurement system. You need to have contemporaneous documentation of your practices. You want to be sure that you're documenting why you're using sole source versus competition. If you're doing competition, you want to make sure that you have the evaluation documents, or that you document your evaluation, and you document your reason for choosing company A over company B, even though, and why maybe a higher price is still more advantageous. And then maintaining this file, with the RFP or the solicitation, any Q&As, the evaluations, and the ultimate award decision. And certainly the price analysis or the cost analysis. Having that all maintained in a contract file is going to be absolutely critical. Again, this is one of those things that it's very hard to do when you're responding to something, situations sometimes life and death, and I get that. But you got to do the very best you can to document this stuff. And even if it's after the fact, doing it contemporaneously, so it's not, you're explaining it 3 years later, or people have moved on and you have no reason why we gave this contract for $3 million to this company, even though, other people could have done it for half of that. So it's really important to have this documented process as you proceed. The other thing is that the uniform guidance, and again, I could spend hours on this, but the uniform guidance has very specific requirements for your RFPs, as well as your contracts. For instance, on the RFPs, you can't have geographic preferences. In other words, if you're in Houston or in Florida or Puerto Rico, the Virgin Islands, you can't say, even though local laws may actually say that you're supposed to be using local contractors, there's a federal rule here that says no geographic preferences. Okay, so that's something that you need to keep out of your solicitation requirements. Okay, you also have to be careful not to kind of unduly restrict competition. You can't write your solicitation so narrow that only one or two, perhaps local providers, can meet those requirements. They need to be broad enough so that people can participate. Another critical thing, and again, I do understand this is all with a grain of salt given, exigency, but is making sure that you're not awarding something to a company that is on the federal government suspended or debarred list. There's a website, www.sam.gov, that you should consult before you give out any contracts to make sure that they're not a federally debarred entity. That is going to be a very tough sell to an OIG many years after the fact to say, we had to go with ABC company, we didn't know they were debarred, we awarded it anyways. That's going to be a tough sell to maintain that contract. And then there's a whole host of things to include in the contract. There's an appendix within the uniform guidance that flows down certain contract requirements. Often these contracts are for construction purposes, so things like Davis-Bacon and other employment laws are going to be flowed down. There's going to be requirements to try to award contracts to minority or women-owned businesses. So these are all some of the things that you need to be thinking about, and having that team that we talked about earlier going through all the requirements, kind of cataloging that all these things are being looked after. And ideally, again, you have someone writing a memo to file that why you considered, doing a contract this way, why you chose this type of contract for perhaps firm fixed price, or you chose T&M, which is less favored, over a firm fixed price. Certainly, there's plenty of reasonable situations where that's the case, but having all of that documented is really going to make your life a lot easier when folks come in after the fact to audit. So having one or two people, or three or four, however many you can, minding kind of compliance is going to be a critical aspect of your organization. And then the last thing to talk about on procurement, because I know we're kind of running up on our hour here and I don't want to take up everyone's time. The last thing to keep in mind is that just when the contract's been let, it's not over with. Sure, the monitoring is not the same as subrecipients, But if you have modifications to the contract, you're going to have certain obligations. If those modifications are within scope, you need to do a price analysis to make sure that the pricing makes sense, but it's within scope, so that's fine. If it's outside the scope of the original competition, then you're going to either have to do a new competition, or you're going to have to do essentially a sole source justification as to why the incumbent contract should do work beyond the scope. And you'll have to justify that, and you'll have to do one of those cost analysis to go with it. So those are just some of the high-level things to be thinking about on the procurement side. Like I said, there's a lot of nuanced requirements there, but certainly this will at least get you started on your thinking.
Okay, last topic for, does anyone have any questions, I guess? Let's take a pause. If you have any questions, you may want to send them to us on the link or webinar. I'm the person in the chat room. Thank you. You can tell I'm so technologically advanced, right? Thank goodness I practiced law. All right. Well, so let's dive into the last main substantive area for our sort of early legal issues, and this is the area that everyone loves to discuss, right? We're all just eagerly waiting to talk about cost, ensuring cost allowability. You know, if we can stress enough anything, it might really be that you really give some thought about how you're going to document your cost controls. You know, we've been involved in it with a number of different disasters. The government contracts and procurement and insurance teams here at Venable have been involved in a number of disasters, and it seems that this question of ensuring that all costs are reasonable and necessary and adequately documented, it always comes up. And it comes up for very, like, obvious reasons of, you know, you're in the middle of a disaster and you've got people that need very basic needs met, and, you know, I'm sure there's a time clock ticking for some of our folks down in the Caribbean that, you know, to get the process of rebuilding moving, you know, to meet spring break, you know, tourism season or whatever it is, you're under the gun, and you hire contractors, you do everything you can that you think is normal, and then you set the system up and let it go. That is not, it's not really enough to just do that. You know, with contractors and subrecipients alike, you've got to be able to ensure that all costs spent against a federal grant are reasonable, necessary, adequately documented, and used for an allowable purpose. Okay, so reasonable costs. If you're able to compete things, that's great. You know, you sort of hit a reasonable threshold. This is the amount that we're charging makes sense, right? We've either done a cost analysis, or we've looked at labor rates from a previously competed contract, or we're literally applying the labor rates from a previously competed contract, and we feel good that the cost is reasonable. Necessary costs. This is really hard because, you know, you got to get people out in the field. Contractors aren't probably going to take a firm fixed price, although I understand the United States government always thinks they will. But no offense to our FEMA friends, we love you. But it just is not, you know, it's unrealistic to think that contractors are going to take a firm fixed price for any major piece of work. And so what you do in that situation is you've got to apply insane control of scope. I mean, you have to understand what the scope is for each of the things that you're asking your contractor to do. You've got to make sure you understand the scope when you issue the contract, because you're going to get, you know, challenges that you could have gotten different rates, you know, if you had, you know, applied an appropriate scope. And you've got to understand and control for scope the entire way through the contract. The reason that you have to do that is that all costs All costs under a grant must be reasonable and necessary, and it's very difficult to get a waiver on that because that is, sort of foundational grant law. Now, you might say, look, we've got people out on the field, we've got our individual Joe Schmo or Sally Mae sitting in the field, and she is watching people, making sure that the workers are there, present, accounted for, that we're not being overcharged for people that are not there, that we've got our fraud controls on scope, right? Just document it. It's so hard to do. I get it, because you're like, we just got to rebuild. We got to get this going. Like these people's livelihoods are at stake. We've got to get this money out. You cannot not document. You have to document. And if it can be, just a couple of pages, you can create some templates. We're happy to give you some templates. But what happens when you don't document is you do all this phenomenal work, and you have people that just spend, 20 hours a day helping to get this thing back up. But then you're, in front of auditors for 10 years after the fact. And nobody wants to be the auditor that doesn't find anything. Again, no offense to anyone on the phone that might be doing audits. We love you. But, auditors want documents. They want to follow the money trail. And so you have to document what your scope is, why the costs that you're incurring are both reasonable and necessary. And you want to then finally make sure that all the costs are allowable against the grant. And this is a very specific term of art that is people spend their entire livelihood reviewing, but you've got to have a person on your team that really understands what an allowable cost is against the federal government contract. Some of it involves questions like reasonable and necessary, and then some of it's very specific. Allowable costs could include direct programmatic expenses, training, legal expenses that don't involve, obviously litigation against the government are allowable. Supplies and approved equipment purchases, those can be allowable. But things like, obviously, alcohol, not allowable. State and local taxes, not allowable. Interest on debt, also not allowable. So put somebody in your organization, hire a CFO, hire somebody that understands how to appropriately vet the costs, how to document them, and how to sort of call balls and strikes before you send this up to the federal government. Okay, and that really just sums it up. This last slide, what I was just saying, you want to establish a system to review the cost. You got to pick the right team who's going to review the cost, and I mean literally all the costs. You're like, well, do I have to review? Yes, you do. The answer is yes. You've got to review all the costs. Develop standard documentation requirements. How do you got a massive amount of costs? How do you review them efficiently? You require people to submit things on standard documents so that you know exactly what you're getting. You can input it exactly in the same method, and then you can pull data on a macro level. You got to involve the procurement team. Organizations, oh my goodness, I cannot tell you the number of headaches we've had where you've got finance going on one side of the house, and this is true generally of organizations, but finance on one side of the house, legal on the other side of the house, program people on the other side of the house, and nobody's talking to each other. So you're missing a major issue. So you got to go on your different lanes, but you got to talk at the top level about what you're seeing, what kind of things could be going wrong. Create a process so invoices are timely reviewed. I mean, there's nothing that makes subrecipients and contractors crankier than for you to be sitting on the money. It's one thing if the federal government hasn't given you the money. It's another thing if you just haven't given it to them. So, yes, that you should give them the money before you verify all the costs. Again, you got to review all costs, and they have to play ball with that, or it's truly it's not worth you doing business with them. But we have to create a system really that recognizes the need also to get the money out the door. And so you've got to put the system in place to timely review invoices. And then you got to ensure that the contracts have clawback provisions. Like today we're talking about trying to get contracts out the door, and we're talking about hurricane relief efforts. We're talking about the devastation that's happened. The news will change very, very quickly, like in a couple of years, to, protecting the federal government against fraud, waste, and abuse. And, you've got to just be prepared to say, look, if you have not done the right things by us, we're going to treat everybody reasonably, but if you have not treated us reasonably, if you have submitted costs that are clearly unallowable, and the federal government asks for money back from us, we're going to ask for you to give us the money back too. So you got to comply with all these things and give money back. Sorry, go ahead, Jay.
Let me just add an example on that, Melanie. So we have clients that have they did review all the costs and everything, but then years later an auditor came in and disallowed because there were some mistakes in the reviewing of the costs. And statute of limitations might prohibit you from clawing back those monies if you don't have a contract provision that survives the statute of limitations. So, you got to keep that in mind, because sometimes, the government's going to come to you, they're going to take the money from you, and if you have a breach of contract claim, but then you've given, it's either been too long or you've given your contractor a lease, you might be stuck holding the bag. So we've seen this happen. So, absolutely, those clawback provisions are going to be critical, and timely reviewing, because you just don't want to deal with it 10 years later when your recourse might have been eliminated. Sorry.
Oh, okay. That about wraps it up for procurement. I'm going to turn it over to Mike Davis for our insurance discussion.
Okay, great. So you can just go to the next slide. There's only one insurance slide. So I'm going to talk a little bit about some insurance issues that you should keep in mind. And the first issue really falls under the heading of duplication of benefits, which was alluded to by the folks that have already spoken, which is that federal agencies generally will not fund matters that are covered by insurance. If you have insurance that's applicable to a loss, whether that's homeowners insurance to help repair a home, or if the state, for example, has insurance for a rail line that got damaged or something like that, then you need to make diligent efforts to tap into the insurance, but not just because of federal funding rules, but it's in your interest because there's not going to be enough money, as Marion indicated at the beginning, to go around. Estimates of the damages from just Harvey and Irma are, I've seen as high as $150 billion. And I've also seen estimates that approximately 25 to 35 billion of that will be covered by insurance. And so even if there's quite a large amount of federal aid given, you can see that the federal aid and the insurance together are likely not going to be sufficient. So this is an area where every dollar counts. But insurance carriers are different, obviously, than the federal government in awarding grants. They have different requirements and goals and priorities, and they may not pay as quickly as the federal government. And they generally only pay costs that, number one, are covered by an insurance policy's coverage grants. So an insurance policy is just a contract, and it will have what we call coverage grants, which will say, we, the insurance carrier, will pay the following. And then they'll only pay if they're not excluded. So following the coverage grant, there'll be a short or a long, usually a long list of things that are excluded. So if it's subject to one of the exclusions, the insurance is not applicable. And then three, the costs have to be proven or provable, meaning you have to have documents that show why these are the right amounts to fix the building or remove the mold or whatever it is that you're doing that you want covered by the insurance policy. So insurance covers a variety of different costs or what are sometimes called perils, meaning what's the cause of the loss. And let me just go through a few that are likely to be applicable in responding to disasters like hurricanes. So first of all, you have wind damage. Wind damage is typically covered by most insurance policies, but there may be limitations depending on the states. For example, in Florida, there may be more limitations. And so with respect to this issue, and really with respect to everything I'm going to talk about, you really have to check your policy to see exactly what it says, but wind damage is frequently covered in commercial policies, as is water damage from rain. So if the roof gets ripped off, or if there are holes in the roof and rain comes in, or rain comes in because of the windows leak or what have you, non-flood insurance may apply there. Where there's more difficulty in commercial insurance as opposed to flood insurance is water damage from a flood. Generally, flood insurance is the only insurance that's going to cover you from damage from a flood. And so the difference between, or the distinction between water damage that came from a flood versus water damage that came from rain that came in because of a leaky roof or what have you can be a major issue that you'll need to have analyzed and assessed depending upon the exact wording of your insurance policy. And for homeowners that don't have flood insurance, this can be the most important insurance issue that they have, differentiating between damage from a flood, which may not be covered if they don't have flood insurance, and damage that is covered by their homeowner's policy. There are other types of things that can be covered by insurance as well. For example, business interruption and related extra expenses. So if there's a local business and it's shut down because of damage, then they can get business interruption expenses paid back, profits that they would have made, or extra expenses. They have to hire extra people to come in and restart their machinery or whatever they need to do to get the plant up and running again. There can be coverage for cancellation of events. So perhaps there was going to be a large trade show in the Virgin Islands or in Puerto Rico and it gets canceled. There can be coverage for that. There can be coverage for damages caused post-hurricane. So, for example, looting and vandalism and those sorts of things can be covered, as can fires. Also in that category of sort of a post-hurricane would be pollution. So if pollutants enter the building or come onto the land or whatever it is that's insured, pollution can be covered. And there's been major payments made by insurance carriers from 9/11 to Sandy to pretty much all of the disasters in recent times for that. And perhaps analogous to pollution would be mold. So in most of the climates that get hit by hurricanes, obviously they're quite warm and humid. And one of the problems that you have when you have a bunch of water and high humidity and no electricity, no air conditioning to keep the humidity down is you have mold. Mold can be very expensive to remediate from hotels or whatever the building is. It can grow on almost any porous surface. So that can be covered by insurance. It can also be excluded. So, details, you have to look at your policy for the details. Insurance can also cover third-party claims. So, for example, if someone was in a piece of property and they got injured, or they have some other third-party claim, that could potentially be covered by insurance. So let me say a word now about notice to insurers. Generally here, with respect to notice, the sooner the better. So the policy will specify how notice is to be provided, i.e. certified mail, overnight delivery, email, to whom it is to be provided, and what information it should contain. And those instructions should be really followed to the letter to avoid any issues with your insurance carrier claiming deficient notice. Now, with respect to notice, there are two major types of insurance policies. One is an occurrence-based policy. So that policy will cover you based on when the occurrence occurred, if the occurrence occurred, i.e. the hurricane, during the policy period. And the other type is called claims made. So that only covers you if the claim is made during the policy period, or sometimes there's an extended period, extended reporting period. And the reason I'm mentioning that is because if you have a claims made policy, it's really better to provide notice of the claims during the policy period and not after it expires. So if you have insurance policies that expire in September or October or even November, you should start taking a quick look at them to make sure if notice is necessary under your current policy that it can be provided before expiration. And in that regard, if you have a claims-made policy but there's no claim yet, you can provide something typically called a notice of facts and circumstances, which is something bad has happened, I haven't got a claim yet, but I know one's coming, and that can stop the clock. So that's something to look for. Now, after you provide your notice, there are certain things that you're going to need to do. One is for first-party damage, i.e. damage to your building or something that you own. Typically, you're going to have to provide a sworn statement of loss. Now, you probably won't be able to prepare that for some time if there's been extensive damage, because you're going to need, to figure out exactly what that costs, and that's going to take some time. But you can provide preliminary statements of loss, that are not binding but can help open the spigot to get some money coming in. You have to save your documentation, or perhaps even create documentation. So what do I mean by that? Well, take pictures. If you're hauling away debris or damage, document that. Invite your insurance carriers to come take a look at it. If there's a hotel that's been damaged and there's insurance for the hotel, you can't just start tearing it down without giving the insurance carrier notice, because the insurance carrier might say, well, hold on, you didn't need to tear it down. You could have just replaced these walls. So before you do anything destructive, think about inviting your insurance carrier to take a look. You might also need help compiling the evidence from experts. You might need architects, you might need construction engineers, you might need mold abatement experts, et cetera. Try to get a dialogue going with your insurance carrier as soon as you can after sending in the notice. Normally, within a few days of sending in the notice, they'll tell you who the claims manager is. Reach out to that person, talk to them, find out what kind of documents they want. That person might be willing to make advance payments. So usually when there's a large loss and that is going to be, 20 million, 50 million, whatever it is, many insurance carriers will make advance payments. Not of the full amount, obviously, but 1 million, 3 million, something, so that you can start having some money to make necessary repairs. Then another issue that can come up with repairs is improvements or enhancements that are required by law. So say your building was built back when the building code was different and there's currently a different building code. Or say that, for example, because of requirements applicable to federal funds, you have to raise the building out of the floodplain. And you have to pay particular attention to your policy to see if it covers those enhancements, so that you don't get into a situation where you're spending money expecting to get it back from the insurance carrier and you can't. A few details on business interruption. There are basically two different types of business interruption coverage, contingent and non-contingent. Non-contingent is where there's physical damage caused by something covered by the policy to the facility. The roof is ripped off so you can't produce widgets. Contingent is where there's off-premises problems. For example, you don't have any electricity so you can't produce your widgets, or you don't have any water, or whatever the case may be. So one thing you have to analyze for immediately is what type of business interruption coverage do you have, and do you have to have physical damage that caused it on your facility as opposed to somewhere else. There are also civil authority issues. What do I mean by that? So if the government says there's a curfew, none of your workers can come to work, is that covered by your policy? There's also issues between total shutdown versus partial shutdown. Often insurance carriers will take the position, hey, if you're not totally shut down, if you can produce at 10% capacity, we're not going to pay you anything. So that's an important issue to look for in business interruption claims. And then, of course, there's issues about how to measure your losses. You don't know, what your profits would have been, so do you look back at the last 3 years, at the last 5 years? Maybe you thought this year was going to be a particularly good year for some reason. Can you use that evidence? And then, of course, there's waiting periods. Usually, business interruption doesn't kick in for some period specified in the policy that you have to be, uninsured. 48 hours, 24 hours, 3 days, whatever it is. Then lastly, let me quickly touch on third-party claims. So third-party claims that would be covered, as I mentioned before, would be suits, say for injury or perhaps for breach of contract. Say that you were under contract to produce something for someone, or you were under contract to host an event, or whatever it may be. There may be third-party claims. And again, it's essential to provide very, very prompt notice of third-party claims, because usually the insurance carrier in many policies will have a duty to defend you in those claims. So not only would they pay if you lose, but they probably also, if it's a duty to defend policy, have an obligation to hire a lawyer for you and do various different other things to protect your interests. So you need to interface with your insurance carrier quite early if you have third-party claims, to make sure that your defense costs are covered and any settlement communications you might have would be covered, because you certainly would not want to have settlement communications without your insurance carrier being involved. So that's a quick overview. I see we're almost at 1:30. That's a quick overview of the insurance issues that you're likely to encounter. And again, as I mentioned before, insurance policies are just contracts, so it's really critical to look at the exact language in your policy.
Mike, this is Biz. Let me add a thought to that. Mike talked about the importance of talking with your insurer about the documents that they're interested in. Don't mistaken the insurance company's requirements with the federal requirements. We've seen this happen a lot where, we met with our insurers and they said it was okay if we document this way and that way. It's not the same necessarily, and people can get into some trouble there if the insurance company, what we've seen is the insurance companies, while they're certainly interested in making sure that all the costs are justified and everything, they have a financial incentive to do that. They don't necessarily look at the same level of detail or with the same degree of scrutiny that an OIG does. So, as Melanie talked about earlier, documenting all those allowable costs, even if the insurance company says, you don't need that, you can just give us this, that may not satisfy your federal requirements. So keep that in mind, that the insurance overlay is sometimes not as stringent as the federal, and in other cases it very well could be more stringent. So just keep in mind that they're two different authorities that are totally independent, and if you set your system up to deal with one but not the other, you could have some gaps or some exposure. So keep that in mind as well.
Great. Well, thank you, Diz. So thank you, everyone, for participating. Marion, did you have any thoughts based on what happened after you spoke at the beginning that you'd like to share while we wait and see if any final questions come in?
I guess I would just say that, having heard all of this about the complicated rules and compliance requirements, don't have it in the back of your head that I said, there are only 20 people at HUD, and feel like that means there are a lot of rules, but they're not strictly enforced. I totally amplify what folks before me have said about ensuring that the files tell the story, because HUD staff, Office of Inspector General staff, and then state, county, or city staff and auditors will all be coming behind and looking at the files. You never actually know which files they're going to look at, but you know that they will be looking, and those decisions at the front end could be very expensive later if not done correctly.
Okay, great. Well, thank you, everyone, for your time. We appreciate you listening, and contact information for all of the presenters, including Terry, who, as I said, unfortunately is in Puerto Rico and unable to call in, are in the slides. So if you have questions and want to reach out to any of the folks that presented, all their contact information is in the materials, and you should feel free to do so. So with that, I'll thank everyone again and end the presentation.